Good morning, ladies and gentlemen. Our first case for argument this morning is Kelly against Allstate. Mr. Fry.
Please the court, counsel. This is an appeal from the district court which determined that there had not been full compliance with the terms of an insurance policy covering his home and contents and therefore entered summary judgment. Our position is the summary judgment was inappropriate and should not have been granted because there had been compliance with all of the items that were able to be produced by Mr. Kelly that they requested, except for an issue about whether he should turn over a Facebook password and identification information to let them copy all of that, or whether they would come to Terre Haute, Indiana, where the policyholder lived, and had his Facebook located to examine that. Allstate's counsel chose, instead of doing that, to keep contending that there was a breach of the policy conditions because Mr. Kelly would not turn that over.
Even before the Facebook messages issue, there's the issue of the examinations under oath. So I think I need your help with that.
I'm sorry, there's an issue regarding what?
The examinations under oath.
Yes.
And whether Mr. Kelly signed the transcript or transcripts. And that's where my question comes from. Okay? He sat twice. Okay?
He sat twice.
He sat 2 different times.
Yes, and he signed the first one as soon as he received it. The second one.
Now that I need to ask you.
Yes.
Is there evidence in the record of him signing that first transcript? Because I don't see it.
Well, I believe there is. I think it was never raised anyway in the district court as to whether the first one wasn't signed. I think there's a record of where counsel sent him back the signed signature page. I'm not sure that's in the record or not.
Okay.
But I think that did occur, and I don't think Mr. Walker will contend that he did not sign the first one. I don't think that's ever been raised.
So that's the August 6, 2021 transcript. And then there's the November 9th, 2021. Mr. Kelly signs that on March 1st. That's
correct.
Okay, do you know the time?
He only received it on March 1st. That's when they sent the court reporter did not send the transcript to him. Mr. Walker contended in December and January that he had not signed it and kept arguing that he was going to declare the policy was not being followed. But Mr. Kelly didn't have the transcript until March 1st. He signed it when he received it.
Do you know the time?
At the time of day?
Yes.
It was in the afternoon. I believe it was sent to him at roughly 10 o'clock. He signed it, I think, at 2 o'clock. It's in the record.
Mm-hmm.
I could look it up, but it's clear it was later the same day, but there's a few hours difference. He had a chance to get the office, read it, sign it,
and by later the same day, you're referring to the fact that that morning he filed the amended complaint, naming the proper party.
I think that's true. I think actually it got filed on the 2nd, I believe, because that's when the summons was tendered to the clerk of the court. But it was around the same time that the second EOA was signed. Yes.
But you would agree he submitted to the court March 1st in the morning.
He signed the
No, I'm talking about the amended complaint naming the proper party for Allstate.
I think it was actually filed March the 3rd by the court, but
now I'm not asking you when the court docketed it.
That's when the court docketed it.
I'm asking when Mr. Kelly filed it.
My understanding is he tendered to the court sometime on the 1st.
In the morning.
In the morning, I believe.
Yeah.
We also contend that the trial court basically looked at Federal Rule of Civil Procedure 15C, which is the amendment of a pleading, to argue that the complaint was actually filed on January 28th of 22, and when it related back for the purposes of protecting the filer from the statute of limitations being an issue. Indiana law requires the tendering of a summons to the court, as we've cited in our brief, to initiate a claim or to bring a claim in action against the party, and that didn't happen until March of 22. It did not happen in January or did not happen back in January when the complaint was filed. The original complaint was filed. And Mr. Kelly, as the court record shows, named the wrong party because he didn't have a copy of the policy. It had been burned in the fire. So when he got it also March 1st, I think, from Mr. Walker. It was sent to him at the same time, I believe, that he he got the second EUO to sign it.
Let's assume we agree with you, not so much on the relation back and the legal issues there, but that March 1st is the relevant date of the complaint that we need to deal with.
I think that's true, depending on whether an action.
I'm in the middle of the question, though.
I'm sorry.
Let's assume we agree with you that March 1st is the date we need to be looking at. You cited Indiana law, and Indiana law also requires exact adherence to the contractual policy, to the terms of the contract,
Right.
which require a signed examination under oath. What's your response to the issue that, as you just explained to the court, Mr. Kelly did not sign the examination under oath until the afternoon of March 1st? He filed the complaint the morning of March 1st.
I think the answer is he didn't have it to sign, so it's impossible to do that. I think this case really involves whether somebody has to do something impossible before they can file a lawsuit.
Well, it seems to me you could be looking at it in an inverted manner, because the policy says you can't sue until you've abided by the terms of this policy.
Correct.
So signing is one of the terms of the policy. He signs it, then he can sue the minute after he signs it, but he's got to sign it first.
Well, it seems to me, Your Honor, that if it happens the same day, the time of day does not make a difference. I mean, he didn't receive the document until that morning.
But if he knows the policy terms of his contract, he knows he can't sue until he receives the thing and signs it. Then he's done his part. Now he can sue.
I agree, but he signed it and then it was transmitted that afternoon to the party the same day. So we believe by the 1st of March he had complied with full compliance with the policy.
So then he could sue.
Well, then he could sue. It would make his suit. It seems to me there's no difference to the defendant here, or in this case, the appellee, as to whether they receive it in the morning or the afternoon. By the same day, the same day the suit was filed, they had the signed EUO in their possession because it was transmitted on the 1st as well.
Is there any Indiana law that says that he complied by March 1st and therefore he complied with the terms of the policy?
There's no Indiana law that says what, with relationship to your question, I think, there's no Indiana law that says that that's compliance with the policy. There is case law in Indiana that says that there's not compliance if you don't sit for the examination under oath, and if you don't tender back a document or documents you have in your possession. The Morris case talks about that. There's no Indiana case yet that says that the failure to actually sign the examination under oath that you sat for is a breach of the policy.
But what does the your duties after loss provision require?
I think it requires you to obtain all the documents that you are requested to obtain. In this case, there were virtually hundreds of documents that Mr. Kelly went and got and provided. Since he had none of those at his home, he had to go out and get them. The case law says you can't refuse to go get things that are available to you. So he did that. I think he has to do that. He has to sit for an examination under oath. He sat for 2. He does have to sign that at some point. But I think they have the transcript already, and I don't know that there's any case yet that has said the failure just to sign it is a breach of the policy conditions. The failure to sit for it clearly is. The failure to, there's a case where they argue back and forth about whether it's appropriate to do it and how to do it, and basically files a suit in the meantime. That's not compliance.
That if we took that argument to its logical end, wouldn't that mean that the duties after loss provision is kind of meaningless? Because and here's why. The policy requires strict compliance with the duties after loss provision. And the duties after loss provision, for instance, says you need to sit for an examination under oath. If the test was, though, you can sit for the examination under oath at any time, so long as you do it, then you could sue whenever you wanted to. In other words, accident, lawsuit, right, then examination under oath.
I agree with you, Judge, that you couldn't refuse to sit under, but I think here he did sit for the examination. They must have had a transcript at some point. We don't know when Allstate got the transcript. We didn't get it for him to sign until the 1st of March. But but he did actually sit for it. I think the refusal to sit for it is certainly always going to be found to be a breach of the policy.
But the policy talks about not just sitting, it talks about signing the
Yeah, it
transcript.
does, that's correct.
So does your argument require us to read that language out of the policy?
I think my argument says that if the only thing there is failing to sign after they've gotten the transcript to the party, there's no case yet that says that is a breach of the policy
Do
itself.
we need a case if that's the plain language of the contract?
It hasn't been reached yet, that this would be the first case that's been done in. I think here it's difficult too to see if there's apparently a 1-year policy period that you have to bring an action in. We believe there's evidence in the record there's 1 or 2 years. We're not really clear which one applies, but if you have to wait to bring suit until after you get the transcript signed and back to you to execute, even though you sat for it, there'd be a failure to comply with the policy. We can't control, the insured can't control when the transcript comes to him. It could be sometime later. I've had court reporters take a good deal longer than this one did to get the transcript to the party to sign the examination under oath. So,
Okay, you're in your rebuttal time, so I won't ask you anything else.
all right, thank you.
Thank you, Mr. Fry. Mr. Walker.
Good morning, Your Honors. May it please the court, my name is Jason Walker. I'm here for Allstate Vehicle and Property Insurance Company. If I may address a couple of issues counsel raised. One, he most recently said that the insured, meaning Mr. Kelly, could not control when the transcript came to him, and I note that in the appellate briefs there was a constant and careful wording of that language. Mr. Kelly signed the transcript when it came to him. But Mr. Kelly was at all times represented by an attorney, and the transcript was prepared by a court reporter in short order after each of the examinations under oath. So at any point in time after the November 2022 EUO, sorry, 2021 EUO, Mr. Kelly's attorney could have ordered that transcript and gotten it. He could have contacted me if there was any trouble that he was having getting that transcript. Instead, he waited until the day he filed suit to actually request a copy of that transcript from the court reporter and then got it. So he absolutely could control when he received that transcript. Counsel referred to or alleged that Mr. Kelly fully complied with the terms and conditions of the policy. Also not true. He did not submit the Facebook archive.
Well, I have a question about that, because show me where the contract requires Mr. Kelly to turn over Facebook messages.
There is no language in the policy, Your Honor, to that effect, and I concede that willingly. The policies are drafted so as to be inclusive and to apply to multiple claims across multiple contexts, and there's no Indiana case law that we could find that said a policy only applies to those specific items enumerated in there. The purpose of those provisions is well fleshed out in Indiana case law, meaning those cooperation provisions are provided to allow the insurance company to fully investigate a claim, and therefore those requests are going to be on a case-by-case basis analyzed with regard to the relevance to that particular claim or investigation. Here, we have Mr. Kelly telling us on the record that he was communicating by way of Facebook Messenger with the one person that could corroborate his alibi on the day of the first fire. And he's telling us that, but not getting us those records. So clearly confirming his whereabouts and activities on the day of the fire, and also his version of events as to why it was that he coincidentally decided to visit a paramour that he had not seen for roughly 20 years.
So can you just confirm for us which language of the policy you're relying on to
Yes.
demand the Facebook messages?
Under the duties after loss, the paragraph that begins with, it's subparagraph E. Produce receipts for any, before that, D. Give us all accounting records, bills, invoices, other vouchers, or certified copies which we may reasonably request to examine and permit us to make copies.
Accounting records, bills, vouchers.
And certified copies, whatever it was.
Of accounting records, bills,
Correct.
and vouchers.
Yes. Yes.
So you want Facebook messages to be bills, vouchers, and accounting records?
We believe that general nature of those cooperation provisions allows an insurance company to request documents, even if they are not specifically enumerated, but if they are reasonably relevant to the insurance company's investigation.
I thought you were going to point me to a general cooperation clause.
I'm sorry, the language in the your duties after loss, meaning that you must give us these documents or give us documents that we request, we interpret that to mean documents that are reasonably related to the subject matter of the investigation. And in this case, there's no question the Facebook archive was in fact reasonably related because Mr. Kelly told us it was. And in fact, after we got it, we did find that there were messages in there with Ms. White, who was the person he went to visit the day of the first fire. Moving forward, if I could, Your Honors, address the issue related to the filing of the complaint. It is a fact that Mr. Kelly filed this complaint back on January 21 of 2022, and then he filed a motion for leave to amend that complaint. The court granted the motion for leave. Mr. Kelly then served that amended complaint upon the proper entity, and that under Rule 15, whether that's the state court version or the federal version, that amended complaint relates back. And I've not heard anything or read anything to explain why that relation back rule would not apply in this case. So it's our position that the district court absolutely got it right, and that Mr. Kelly's amended complaint does relate back to the original filing date, making it well before he signed the EO transcript. But as Your Honor noted, even if we were to take the March 1 date of filing as the correct date, it still would have been filed in the morning before he actually signed the EO transcript. So in either case, he did not satisfy that portion of the policy. And the policy provision that requires his signature is in the conjunctive, right? So as Your Honor pointed out, the EUO provision, part of the policy that requires him to submit to an EUO and then to sign that transcript, that's a single condition, and the connecting clause, that and, is conjunctive, meaning to satisfy it, you have to both sit for the EUO and sign it. So we would say that he did not actually satisfy the EUO condition, but even if he wanted to parse that out, split it into two, and say that he did sit for the EUO, he still nonetheless did not.
I wish you would use real words rather than weird initialisms.
I apologize, I don't know what initialism is, Your Honor.
You might think of it as an acronym, but it's not. It's not pronounceable.
Examination under oath.
Yes.
Absolutely.
Use real words instead of made-up things that aren't in dictionaries.
Understood. I will call it an examination under oath. The transcript was something he was required to sign, and he did not do it. It seems very straightforward from our position. The Facebook archive, we believe, was something that he was required to produce. He did not do so until after he filed suit, and it was clearly relevant, and it prevented Allstate from asking him questions about it. And so we would say that his failure to do that, even if we wanted to review that portion of the policy as under a prejudicial standard, even if we didn't want to say it required exact compliance with the document production, it nonetheless absolutely did prejudice Allstate in its ability to confront Mr. Kelly with the information in that archive. Allstate was not requesting his ID and password. We didn't want that. Allstate wanted the Facebook archive. We offered to help him download it, and in order to do that, he would need to give us that information. And at one point, it seemed like he had no problem with that. Later on, he changed his mind and didn't want to give it to us. But Allstate had no interest in his Facebook password or ID, and I had conversations with counsel, explained to him that we could do it for him, but it would still, the actual archive itself would be sent to Mr. Kelly, and then he'd have to send it back to us, and he could simply change his password and resecure the whole thing. So I just wanted to clarify that Allstate's interest was in the substance of the archive and not in his ID or password.
At this point, Allstate has everything it needs, though, because he ultimately agreed to turn over and did then turn over the Facebook information.
Yes, Your Honor, after he filed suit, he did give us the archive, and he did sign the transcript of the examination under oath. Correct.
Okay.
So, Your Honor, I believe that the rest, I've addressed what I need to with counsel. I don't have anything more to add on this topic, so I would just yield the rest of my time. If there's no other questions,
Thank you, counsel.
thank you.
Anything further, Mr. Fry?
Yes, briefly, if I may. With regard to the Facebook issue, as far back as December, Mr. Nichols, who represented Mr. Kelly, was trying to get Mr. Walker to come and look at the Facebook and download it himself, and he gave him his cell phone number. The record shows he made an effort to try to get them to come and actually download it in Terre Haute, and Mr. Walker even agreed at one point that he would send somebody from Allstate to come to the office and download that, and they never did that. Rather, they wanted to avoid the policy by not having to pay any damages to Mr. Kelly. So he pursued the summary judgment instead. I don't know the district court actually relied on the Facebook issue. It talks about it. It says that he was required to do certain things under that. I don't know the policy does require that. I don't think there's ever been a case yet in Indiana saying the failure to turn over Facebook information or give the password and ID for the Facebook account is a failure to cooperate and failure to comply with the terms of the policy. This would be a first case that says that. It's clear to us that from December on, Allstate was trying to get out of paying this damage claim. They demanded things such as the Facebook archives that we couldn't produce. Mr. Kelly tried to download it, tried to copy it, couldn't do that, and told them that. We wrote their emails in the record showing that they said, come look at it, you can do that, we can't do it. And they didn't want to do that, they wanted to avoid the policy. So that's our position. Thank you for your time, judges.
Thank you. The case is taken under advisement, and the court will take a brief recess before calling the second case. We're ready for argument now in the case of Harris against Milwaukee. Mr. Borton.
May it please the court, counsel. I have the honor of representing Ms. Santosha Harris in the bankruptcy estate of Ms. Santosha Harris proper. In this case, she has filed claims against the city of Milwaukee, as well as defendant Terrence Bremersky, her former supervisor, under the Civil Rights Act of 1964, particularly Title VII, for claims of quid pro quo harassment, hostile work environment, as well as retaliation. There is a separate claim filed as well for a Section 1983 claim against the city of Milwaukee. Ms. Harris has been employed by the city of Milwaukee as an infrastructure repair worker working in the barricade shop since as early as 2010. In 2012, Mr. Bremersky was promoted to be her direct supervisor, overseeing her daily tasks, as well as giving her assignments and signing off on her performance reviews during her career. Over that period of time, Mr. Bremersky sexually not only assaulted but verbally abused my client over that period of time, coming into an incident that occurred on May 25th, 2017.
Let me just go back up a minute and ask you about that. Mr. Bremersky, you say direct supervisor, they say no. What's your response to their view of how he's not her direct supervisor and how the Title VII definition of supervisor is different from a lay definition of supervisor?
Correct, and that's been thrown around much throughout the case, the supervisor terminology. In Title VII, I agree, is a supervisor has an inherent powers given them to hire, fire, as well as reassign. Now, I agree, and my client agrees that Mr. Bremersky may not have inherently had the authority to hire or fire her or dock her pay directly, but he did have the authority to reassign her, and there's much argument made between counsel on that issue. My understanding of the case law and reviewing it extensively is there's not a hard and fast rule about what is what qualifies as a actionable reassignment. In this case, my client was threatened by Mr. Bremersky to be reassigned from her position to go work outdoors and pick up trash at times. So my opinion in reading the case law, particularly in Burlington Northern and Santa Fe versus White, the perspective of which a material reassignment is judged under Title VII is from the perspective of the reasonable person in my client's shoes. And my client certainly viewed that as a tangible reassignment that would qualify, that would make, rise to the level of qualifying Mr. Bremersky as having that inherent reassignment authority, making him her supervisor.
Counsel, I don't understand what you mean. That's now about the third time you've used the word inherent. Is it something he was born with? Authority is what the employer gives him. It's not inherent in anything. So what function are you asking us to use with that word?
Inherently given to him by his employer.
Then it's not inherent. We just need to ask what authority his employer had given him.
He had the authority to reassign her.
You also, when you were laying out the facts, you described him as directing her activities. So should our analysis of the supervisor question rest with the reassignment issue? Or do you also claim, it seems as if you are, that he had the power to direct her activities separate and apart from a reassignment? Or is the directing activities only referring to the reassignment? Do you understand my question?
Correct, and that's, I think, a distinction that's been made over the case law history about what is a daily activity in directing her work on a given day versus reassigning her to something that is outside the scope of what she's been hired to do. And I believe counsel for the city of Milwaukee has argued that outdoor work and picking up trash and sanitation around the building was always a part of her job duties, but that's just not in the record. That was never something she was asked to do. It's not something that she ever did before.
Is there a written description of her job duties in the record?
There is one description of her job duties that was put into the record by the city that spans the scope of 2016 to 2022.
I'm really confused by it though, and the record, because the record, the written job description does refer to remove debris from the work site, and it does refer to removal of brush, grass, and weeds. So when Miss Harris is talking about the trash assignment, I also see in the record references to it being an assignment to go with the garbage truck around the city to pick up trash, not trash related solely to the work site. So what is it? What was Burmiski threatening? Was it this worksite trash, which does seem to be in this job description, or was it general trash duty on garbage trucks around the city?
It was general reassignment outside of the barricade shop where she was, within the streets division of DPW in the city of Milwaukee. So that would be different than her position as an IRW in the streets division assigned to the barricade shop.
But this IRW, well, this, let's see what this is. Infrastructure Services, Department of Public Works. This does talk about removing debris from the work site. So it is in her description to remove trash around work sites and to remove brush, grass, and weeds.
At least as of 2016. And I do not believe in, if we are using the looking glass for judging what her job assignments were at the time, in judging a reassignment from her perspective, if this is not even communicated to her that this is somehow a new job assignment she has, and again, this is a description from 2016, and this has been going on since 2012, these threats of reassignment, I don't think that you can make the leap to say that she's been, that this is now some kind of new reassignment that fits within the scope of her job description.
So you're right that we don't have a job description from 2012 through 2015.
Correct.
Which are the years that the harassment first started.
Correct.
This is summary judgment though.
Correct. Continuing on the hostile work environment claims, particularly even if the court were to find that Mr. Boberski did not qualify as her supervisor under Title VII, there is still liability for the city as a co-worker if they cannot meet the prongs of the affirmative defenses. Particularly, the city has argued that Ms. Harris acted unreasonably, and we vociferously dispute that, particularly pointing to the totality of the circumstances when she sends the letter to the designated reporter, Dan Thomas, in 2012. While we admit that that was sent anonymously and Mr. Thomas denies receiving it, Ms. Harris has testified that she sent it complaining of the harassment. As well, over that same time period and over the years, she complained to a mandatory reporting authority in Deetra Hartnett, who was a supervisor for the years 2012 through 2017. There is nothing in the record that she reported these complaints up the chain of command. That is the city's policy, and the writer of that policy, Dan Thomas, admits in his deposition that he would expect her to report those complaints if she had received them. My client says she received them for a number of years, and Ms. Hartnett actually accompanied my client to the job site at 6 a.m. to kind of buffer Mr. Boberski's advances when he would make them in the mornings, as well as advising my client to also record him. So if we look at kind of the case law and similar facts, particularly in UPS versus Clark. There was a situation where a mandatory reporting authority had received a complaint but believed that the complaining individual was not actually feeling threatened and made a judgment call to not send it up the chain of command, and that was found to be a violation of the policy.
But, you know, Ms. Hartnett says she wasn't a supervisor. What do we do with that? Because you do want us to believe aspects of her deposition testimony, but not that part, I guess.
Well, and I believe that is the city's issue. It was summary judgment was granted to the city on undisputed facts. It's at least a disputed fact, in my opinion. She is submitting a resume for a promotion and representing that she is this particular individual for that period of time. If she says she doesn't remember and she would refer back to the records, I would, which is what she said in her deposition, I would think that the actual record of her resume that she submitted would be an accurate representation of what she is. There is no other document in the record currently that shows whether or not she was that position, which I submit needs to be determined. I'd reserve my time, my remaining time for rebuttal. Thank you.
Certainly, Mr. Borton. Ms. Headley.
May it please the court. Good morning, Your Honors, Counsel. Catherine Headley representing the city of Milwaukee. At the table, Counsel Vicki Arrowwood from Emil Banks and Associates represents Mr. Terrence Bremersky. Although there are no claims against him before this bench today, the appellant did raise both of us, so that is why she is here. I want to first start off with a great question in terms of what exactly it is that we are dealing with here for the scope of Ms. Harris's job assignment. So she is an infrastructure repair worker. That is a city laborer position. If the court would review the Thomas transcript, which is in the record at ECF 50, exhibit number 4, in that he describes what exactly it is the job duties are. Job duties have remained consistent and similar for infrastructure repair workers. They are to patch potholes in the streets of Milwaukee. They are to build barricades. They are to do various laboring activities. Justice Jackson, you're correct with the city submits that her job description generally allows for and provides that she must clean debris as necessary. So would that be the work site on the street when filling potholes, or while in the facility itself?
But what I don't see in this job description, and we don't have a job description for 2012 to 2015. We only have this 2016 job description. Okay, so that's one thing. But what I don't see in here is what she says Bremersky was threatening her with, which is putting her on a garbage truck to go around the city collecting trash. I don't see that in here.
I would disagree with counsel's representation that that's what he was threatening her with.
Well, it's not counsel's representation. We have Ms. Harris's words.
My understanding from her deposition was that she was complaining about being put on the garbage route when the administrator was investigating her claims of sexual harassment.
No, it seems to me, reading the record, there are two different instances of trash complaints that Ms. Harris has. She has a complaint you just referred to that she was put on trash duty while they were investigating. 33 days, done. But she also said earlier, during the time she was being harassed by Mr. Bremersky, he would say things to her like, "You don't want me to put you on trash duty." And that she described as being put on a garbage truck and sent around the city. And I'm asking, where is that in this job description?
That is not in the job description. That would require a commercial driver's license and a different job description to do.
Not driving. She could be the loader, the laborer on the truck. So the person who gets on and off the truck and gets the trash. And you don't need to be driving the truck to do that.
both positions require a commercial driver's license for the city of Milwaukee.
Okay, and so that is not in her job description?
Correct.
So what he was threatening with her with was not in her job description?
It was not in her job description, nor did Mr. Bermersky have any authority to do that. And I do want to make that clear. So my review of the case law is that an employer, or a supervisor is an individual who has been empowered to make a tangible employment decision, such as reassignment to a different job description. So there was, in this case, there's copious amounts of evidence in the record. Mr. Thomas testified to it. Mr. Bermersky himself testified to it. He would not have the ability to transfer her from an infrastructure repair worker to a operations driver worker.
So then I need you to address two things for us this morning. One, Mr. Borton's point that we view this from the perspective of the employee when they're in the middle of the harassment. Okay? So that's point number one. And then number two, for retaliation, the standard as we've enunciated is what would dissuade a reasonable employee, I'm paraphrasing, from engaging in protected activity. And so address, please, Bermersky's threats on those two axes, not on his actual authority to move her to garbage duty around the city.
Sure. For purposes of retaliation, I would submit that that is inapplicable here. So her retaliation claim comes from what happens after she has an interview with Mr. Thomas. That's when she says the retaliation began. That's when she said she was moved to dumpster watch. That's when she said a camera was installed in her work environment, etc. So that, from my understanding and from what we've briefed it on, that is the retaliation claim that she's brought up at the district court level. So I want to make that clear. That's my understanding of what we have. And then to your first point, I'm so sorry, I forgot what that question was. Could you repeat it for
Mr.
me?
Borton has told us this morning that he wants us to concentrate on the part of the case law that says you judge from the perspective of the employee this issue of authority and reassignment.
Sure. And to that, I would say
Employee, yeah.
Correct. And there are several cases in this district and other circuits that indicate that while we do view it from the perspective of the employee, it still has to be reasonable, right? And so in this case, they had no, Mr. Bermersky had no authority to, even though he was allegedly blustering and allegedly saying that he could get her transferred, he could do whatever it is that he wanted to do. He was friends with this person and that person. There is case law that indicates that making those broad associations or making those grand proclamations does not equate to having the actual authority. And I would bring the court's attention back to the fact that the employer has to empower the individual to actually be able to do these things. There's no ability for him to do it. So, to that point, because he was not able to make any tangible employment decisions, he was not able to, as counsel agreed and conceded, he could not hire, fire, demote, promote, retain, pay, or anything like that. He may have, and again, this is something that's subject to debate because it hasn't been, brought to the court and a decision hasn't been made or liability hasn't been found one way or the other. The allegation is that he made these threats to Miss Harris, but Miss Harris didn't do anything with that information. And I want to go ahead and really focus on that aspect of it, because if an employee is not a supervisor, which again the city submits because he had no ability, he had no authority to do any of the actions that this circuit and this U.S. Supreme Court has indicated would make an individual their supervisor, again a legal supervisor, not necessarily a supervisor for purposes of common word choice here, but because he was not a supervisor, the city then shifts to a coworker liability. And within the coworker liability, the city submits that it has the ability and it is entitled to the other offense. So the city had a reasonable policy that indicated if an individual felt threatened or harassed at work, that they could report it to Dan Thomas specifically. He's specifically named in the policy, as well as the Department of Employee Relations, or DER. Justice Easterbrook, I don't want to use another initialism for you, but the city is full of them, unfortunately. They would have the ability to report to Dan Thomas, or to report up their chain of command. In this case, since its inception, and seemingly Ms. Harris has put forth again and again that she submitted an anonymous letter in 2012, and from there the city should have been on some sort of notice that this was happening. She has very little, if you look at the transcript, there's very little indication of when that letter was sent. There's no postmark date for that. She claims to have sent it to Mr. Bermersky's live-in girlfriend. Mr. Bermersky has never received that letter. His girlfriend never received that letter. An unknown alderman, when pressed if she could name the alderman, no idea. And then we don't have a date and time wherein she sent it. Maybe sometime in the summer, maybe not. All of these things are very nebulous. What we do have is information from Mr. Bermersky and information from Mr. Thomas that said they never received that letter. Moreover, during her deposition, Ms. Harris, when asked if somebody confronted you with that letter in 2012 and said, "Did you write this, or are you being harassed at work?" what would you have said? Would you have said, "Yes, I am"? And she said that she didn't know what she would say. So this hypothetical situation that counsel points to, saying that the city was on notice in 2012, is just that. It's a hypothetical. There's no actual demonstrative proof. We have the notice, but there's no metadata. We have the anonymous letter that was sent, but there was no metadata indicating when it was sent, when it was drafted. And so I would like to point out that I think that is kind of a red herring. More importantly, when the city actually received notice, and I do want to take a second to just briefly discuss the timeline here. The events allegedly that Mr. Borton was alluding to earlier, and that I don't want to get into the specifics with due to Ms. Harris's privacy, occurred on May 26th, I believe, May 25th, I believe. My apologies. That was a Thursday before Memorial Day weekend. So a 3-day weekend elapsed in that time period, and the city was still able to get this information and immediately investigate it within 5 days of the event taking place, allegedly. So in terms of when the city actually received notice, it immediately acted, or near about immediately as one can get with notices of that. I want to go ahead and take a second to indicate that the removal of Ms. Harris at that point in time, as I alluded to earlier, was not due to any retaliation, but rather due to investigation.
Was she ever informed as to the reason for giving her another job assignment at that point? Was she told that this was a protective measure?
My understanding of it is yes. I could not point to a line in the transcript right now that would clearly enunciate that, but I do believe it is a part of Dan Thomas's testimony in his deposition.
And was she told that it was a temporary matter?
Yes, and she was moved back to her position as soon as the investigation was complete. More importantly, and moreover that I really do want to highlight here, is Ms. Harris's lack of cooperation with that own investigation, which goes to that second LRF point, which is the employee unreasonably failed to take advantage of the protective or corrective opportunities.
Is there any standard operating procedure committed to writing that says, in the case of a sexual harassment complaint, that the alleged victim will be removed from the supervision of the accused perpetrator?
I do not believe it is in writing. I don't know if that's something that the city would want to put down in writing.
Why is that?
I don't. I think that might be a policy decision based on each individual department. So I would have to look at the department rules to get the clarity on what the Department of Public Works does.
Of course, it could be phrased in fairly general terms. but,
Correct.
So that the city had some latitude, but I was kind of surprised there wasn't something.
It'd be a good point, and I can bring it up to our departments to ensure that they have something like that in writing. However, I do know that it is the policy, or that is the customary practice, and I believe Dan Thomas does in fact testify as to such. He makes these decisions. I will take a step back. The city's job obviously is to put forth the resources and the necessary fundamental jobs of a city, if that makes any sense. In this case, with the Department of Public Works, the streets, sanitation, sewers, etc. So when you have an individual who can be removed and not interrupt that operation, that's the person who's going to be moved. So whether that be the alleged victim or an alleged perpetrator for purposes of the investigation. Once that information came through, and this is the point that I want to make briefly, Ms. Harris, and I'm sure Mr. Borton will talk about this, allegedly recorded her conversations with Mr. Bremersky for a period of 5 years every single day. When asked if she had any information that said that she was being harassed, she did not supply that information. She did not supply the 2012 letter, and she did not supply any information regarding whether or not she was in fact harassed. I do see that I am running out of time briefly, so the city would request that this court affirm Judge Joseph's order dismissing the case. If there's no further questions.
Thank you, Ms. Headley.
Thank you.
Anything further, Mr. Borton?
I'd like to touch on the city's anti-harassment policy, which is contained within a large document of its work rules that they hand a very large packet to its employees every year to, quote, read and sign. They don't walk through it at all. They don't discuss anti-harassment or how to report it correctly. They are handed a large pack of rules that says sign it so you can work, and they're not allowed to return to work unless they sign that. Additionally, in addition to the written policy, Dan Thomas, the author of the policy, has stated outside of what's there in writing is that any employee experiencing this type of harassment has the ability to go to any supervisor and complain of it. Again, when asked about complaints made to Ms. Hartnett by Ms. Harris, pre the May 25, 2017 incident, he confirmed that that in his perspective, Ms. Hartnett would have been required to report it, and that did not happen. There is the instance of the other employee, Carrie Graves, who was confronted with some demeaning language from Mr. Bremersky in a sexual nature, to which she reported to a mandatory reporting authority, and there is no evidence in Mr. Bremersky's entire employment file that was produced to us that this ever got up the chain of command. And it begs the question how effective this policy was in practice. And as looking in the case law, merely having a sexual harassment policy will not shield a company from its responsibility to actively prevent sexual harassment in the workplace. The policy must not only be reasonably effective on paper, but also reasonably effective in practice. And I think that the evidence, there is more than enough evidence in the testimony of the countless women that have been deposed that experienced unfortunate harassment by Mr. Bremersky. It begs the question why none of this got brought to the attention of presumably the only person who can put the city on notice, which is Dan Thomas. I think it demonstrates a failure of the administration to train its mandatory reporting authorities to send it up the chain of command. And I'd also note that none of the supposed anti-sexual harassment training materials exist. They were not produced to me. There is one note in Mr. Bermersky's file of a training back in 1999. Other than that, it's replete with anything else. There has been testimony that there is now, after my client's situation, that there is mandatory sexual harassment training that did not exist prior to. So looking at all these things and taking in the totality of the circumstances of what happened, I believe that my client has actionable claims under Title VII, and particularly whether or not the city is found to be strictly liable as Mr. Bermersky is her supervisor, or there is also co-worker liability. As to the retaliation claim, Ms. Headley is correct, and I can clarify that today. The retaliation claim is premised on the actions of the city following the May 2015-2017 incident when she was reassigned to pick up trash, and she is now required to pick up trash outside the building as well. Additionally, she had an office that was torn down afterwards, as well as a camera placed right above where she was working. I do see that I'm low on time, and I would just ask that the...
Thank you, counsel.
Thank you.
The case is taken under advisement. Our next case for argument is Consolino against Dart.
Good morning, Your Honors.
Mr. Casper.
Good morning, Your Honors. May it please the Court. My name is Cass Casper. I represent the plaintiffs in this matter. We are here on appeal from review of the District Court's grant of summary judgment. There's an expression that revenge is a dish best served cold. And yet, our case law, particularly the Kidwell versus Eisenhower case, which has been cited 1,123 times according to Westlaw, more often than not for the timing rule, is strangely divorced from that expression. And what we are seeing in our district court decisions, there's two threads of decisions, is a tendency to analyze...
We are not here to discuss what we are seeing in our district courts.
Sorry.
We're here to discuss this case.
Yes, Judge. Thank you. It is my belief that what the district court did was that it isolated timing and it considered it in a vacuum without considering that this is truly a timing plus case, timing plus other bona fide circumstantial evidence. And that by isolating timing, what the district court did is dispatched with it without considering the fact that it must be considered with other circumstantial evidence. This error in the district court's reasoning below seems to emerge from its reliance on the Kidwell versus Eisenhower case, as well as the Bless versus Cook County case, where the usefulness of timing is reduced to the rule in order for timing to give rise to an inference of retaliation. It must be no more.
I'm just getting lost.
Sorry?
The district judge found, and I take it you agree, that the sheriff's budget actually was cut by 10%, and that people had to be let go. I take it that it is agreed that all of the commanders, without exception, were let go.
That is agreed.
Is that true?
Yes.
How can one show that that is a pretext of any kind?
It is our belief that a jury could find that the decision to select the commanders was itself the retaliatory action. In other words,
I could imagine an argument along those lines if some vocal commanders were let go and others not. But you agree that every commander was let go.
nearly every commander was let go. There was one in the record who was not let go. But that thread of evidence was not really pursued. But we submit all the commanders were vocal because the recommended decision and order from August 2nd, 2017 was the culmination of all of their collective protected activity. That was not a recommended decision and order as to 1, 2, or 6 commanders. It unionized all of them. So we submit that to consider the commanders separately is not an appropriate way to look at this case. It's to look at them as a whole, as engaging in protected activity as a whole.
Prior to the decision of the administrative law judge and the NLRB, were the commanders considered exempt from the political hiring restrictions?
There is some evidence in the record that they were exempt, but that term, it was never clarified what that truly means, if it's exempt in the Rutan or those lines of cases, exempt in the confidential line of cases. It's never clear in the record what that actually means versus them just being on an exempt list. And it's our position here that the union activity was First Amendment protected activity. And defendants really don't elaborate on that point in their brief or in the record below. That was not.
Well, certainly the sheriff lost control, was going to lose control of these guys, these commanders, if that NLRB decision at the trial level stuck, right?
I don't know that we can know that. I mean, I don't think there's any indication in the record that they would have been disloyal. I mean, the fundamental thing they were attempting to do at the labor board was to improve their working conditions, improve their shifts, improving their wages and working conditions. And I don't know that it.
Well, if they're considered by the NLRB to be worker bees, as it sounds like the sheriff would have a pretty hard time justifying that he had some political control over them.
I don't think the ILRB decision ever.
I understand it. I understand that. I'm trying to look at this from the point of view of why the sheriff did what he did with the commanders.
Well, we submit that if he did do that, that would actually be an act of retaliation. After all they did was attempted to form a union, and they did so reasonably successfully as of August 2nd when the recommended decision order came out. And our theory of the case is that they used the budget excuse as an excuse to retaliate against them. That's the theory of this case.
By the way, where does this right to form a union in the public sector come from?
The Illinois Labor Relations Act.
Right, it's state law, not the Constitution. I'm a little surprised that you haven't cited, nor, for that matter, has the sheriff, cited 3 decisions of the Supreme Court that held that the First Amendment has nothing to do with public sector unions, and that public sector employers are free to discriminate against people who want public sector unions. Now, those are holdings of the Supreme Court, which everybody has ignored. And I take it, under the party presentation principle, we will ignore them too. But it's an important background principle.
I think that there's some nuances in the law under a First Amendment speech claim as opposed to an association claim. And admittedly, these cases weren't presented as Your Honor states, but I'm not sure that those cases would water down the association claim as much as they might be applicable to the speech claim.
Well, one case says, the First Amendment does not impose any obligation on the government to listen to, respond to, recognize, or bargain with a public sector union. That's Smith against highway employees. It didn't say which part of the First Amendment. It's just not there. But as I say, the sheriff has not made this argument. So you should count yourself very lucky.
Thank you, Your Honor. If there was additional briefing required by the court, I'd be happy to look on this.
If we require additional briefs, we will let you know.
Thank you, Your Honor. So, moving back to this timing issue that the district court erred on, I believe, the point we're trying to make here is that by considering it in a vacuum and not as part of an overall convincing mosaic, it gives too little weight to the importance of the timing here.
You realize we have abolished the convincing mosaic nonsense. Lawyers and district judges keep talking about it, we had an opinion circulated under Circuit Rule 40 telling people to stop talking like that. I'm surprised that it continues.
Duly noted, Your Honor. I will stop with that immediately. So moving away from that, the other pieces.
Your point, though, Mr. Casper, still stands. Your point in using the language that you were using, I take it to be, is you throw all the evidence in the pile, and you look at all the evidence together in the pile, you all have made a prima facie case.
That is our argument. That's the argument we're making, Your Honor. And the other major piece of circumstantial evidence we wanted to highlight in court today is the new hire evidence. And this is by far the largest piece of circumstantial evidence we have. In nearly the same week that the commanders were fired, or laid off, whatever nomenclature we use, the sheriff is hiring 12 new people. And this is according to their own business records.
Now, but there's no evidence in the record that they hired anybody to fill the commander's positions. Indeed, those positions were disbanded. The duties were then dispersed, reassigned elsewhere in the department. So let me ask you this. If we discount the new hire evidence, okay, just as the district court did, do you still win?
I believe we do, because when we still have the timing evidence, we have the shifting explanations between all the different folks who were deposed, between Brad Curry and Matt Burke and Nika Jones-Tapia. We've got the seam issues that were discussed extensively below. We've got the, the fact that HR was mysteriously cut out of this entire process without, in our view, reasonable explanation.
Do you have anything in the record that tells us that HR is normally involved in these decisions about who to cut and when?
We don't have that evidence, but we submit that HR is is a classic function of HR to be involved in hiring, firing, pay issues, all kinds of employee issues. And for whatever reason, in this particular instance,
do you need the HR evidence to win?
No, I don't need that either. We've still got the timing. We've got the shifting explanations. We've got all the other pieces of circumstantial evidence in this record. We've got the fact that it was only the commanders who were seemingly laid off, and they were not called back. Some of the other folks who were laid off were called back just the following year, just a few months later. So why, and overall, thematically, it is that absolute, we are going to lay off the commanders no matter what attitude that permeates this record. That is itself a piece of circumstantial evidence.
Well, now,
why?
Isn't there some evidence in the record as well, though, that the sheriff's office considered a lot of other cost-saving mechanisms that could be used to affect the cost savings they needed to get around the soda tax? I mean, really, there's no evidence that they just focused on the commanders, is there?
We submit that Brad Curry, who was admittedly the ultimate decision maker, ignored all the other options, ignored them because he was so hyper-focused on getting rid of the commanders. So yes, they did try to make the case about that in the discovery process that they considered these other options, but Brad Curry never actually truly considered them. He was going to lay off the commanders.
How do we know that?
From his testimony.
What does he say that makes your case?
Overall, the impression we have from him is that, well, for example, we have Matt Burke and Nika Jones-Tapia and Jeff Johnson, who are sort of operational directors under him, coming to him with alternatives to save the commanders. And he still doesn't accept any of those alternatives. In fact, Matt Burke said that these were operationally feasible and fiscally feasible alternatives, and Brad Curry still doesn't consider them. It is the commanders that he's going for.
Does Mr. Curry at any point in his testimony indicate that why he is focused on the commanders?
I'm sorry, I missed the first part.
Does he ever indicate why he is focused on the commanders?
No, we don't have a statement from him that says why it's the commanders in particular, and that is the very curiosity of it. Why this fixation from him on the commanders, especially when we have 12 other people being hired for $650,000 about the same week that our folks are being laid off? I mean, that mismatching conduct.
That happens all the time during budget cuts. This place needs people or needs to replace people in other roles, and it really is a wash on the budget cut, so you don't worry about it.
But the question, that could be so, Your Honor, but the question here is, was this used as a pretext to off the commanders who just won their union decision? That's the issue, and we submit that ignoring that 12 other new hires the same week, that is a slugger piece of circumstantial evidence. To your point, maybe a jury would see it completely the other way, and we have it all wrong. But we submit this was decided on summary judgment. And with these pieces of circumstantial evidence, Your Honors, this is enough to give these commanders that jury. Let the jury decide, in our view. And the district court, one other thing I want to focus on here, with respect to the new hire evidence, it seemed to require that the plaintiffs have to prove a one-to-one, savings plus costs, like the new hires would cost exactly the same as the laid-off commanders would save in order to make this argument work. And that is in the district court decision, and it's not, we submit, that's not what's required by the law. It's the piles of circumstantial evidence. And we submit this inconsistent conduct, together with the timing, together with the heck-bent focus on the commanders by Curry, those all together create that inference. And this should have gotten to a jury. I will yield the remainder of my time. I think I'd saved 3 minutes for rebuttal, unless there's further questions right now.
Mm-hmm.
Okay, thank you.
Certainly, counsel. Mr. Leinenweber.
Good morning. May it please the court. I'd like to begin by briefly answering Judge Ripple's question regarding why Chief Curry selected the commanders. And there is evidence in the record, and Chief Curry testified that the reason he selected the commanders was that as leadership went through the various positions in the Department of Corrections, that the duties of the commanders, he believed, could be divided up between lieutenants and superintendents, with them assuming some of those responsibilities and picking up those things. So it wasn't a situation where Chief Curry willy-nilly selected the commanders. He believed, and he testified, that it was operationally feasible for the Department of Corrections to continue to operate without the commander position.
But you're not discounting or disagreeing that there's also evidence in the record that no fewer than 3 other people, Jones, Tapia, Burke, and Johnson, believe that alternatives to firing the commander were operationally feasible and fiscally sound and met the county's demands. We've got testimony from all 3 of those people, and that they presented those options to Curry, but he did not select them.
That's correct, Judge.
Okay.
Those individuals who were his direct reports in the Department of Corrections were tasked with looking into this and coming up with various possible scenarios under which budget cuts could be made. They did put forth a number of positions. It's routinely testified to, nobody wanted to let anybody go. This was an unprecedented budget crisis. Those individuals, Mr. Burke and Jones Tapia, they did put forth an effort to try and save those positions. However, Chief Curry, who is where the dollar stopped, decided that would not work. And he simply did not believe those things would work. For example, he testified that, how would I choose one commander versus another here? How can I move some down to lieutenant when the lieutenants then would have to bump down to sergeants? And we would have this sort of trickle down where the county wouldn't end up saving the requisite money. Or it would take so long that the budget deadline would come and the county board would simply make the decision of which positions to cut.
Now, isn't the question, not whether the county is right here or the commanders are right here, but just whether this should have gone to a jury?
The question here, there are 2 reasons, Your Honor, here that this was correctly decided and should not have gone to a jury. No reasonable jury could look at this record and conclude that it was more likely than not that plaintiffs had proved their case that their union activities, which occurred years before and months before when the recommended decision and order was issued, was what caused their selection for the layoff. And even if plaintiffs could get over that hurdle, they still need to get over the pretext hurdle. And there is no circumstance under which a reasonable jury could conclude that the legitimate, non-retaliatory reason for the layoffs, admittedly, budget cuts required by Cook County, could have been a lie made up to select these commanders to get rid of them for their union activities. There's been so much discussion in Mr. Casper's brief regarding the timing and did the court examine the timing alone. First of all, the court considered all of the evidence. And the timing evidence here, which is important, timing is important here. It is the context, and the case law directs you have to look at the context in which these decisions were made. The context here, the timing here shows that the sheriff's office had roughly 2 to 3 weeks within which to come up with these cuts. The sheriff the soda tax, which is the genesis of why we're here today, because the soda tax was repealed on October 11th, 2017. Just 2 weeks later, the sheriff's office held its budget hearing with the Cook County Board. Those board members said, Sheriff Dart, why do you have so many layers of supervision in the Department of Corrections? And for context here, it's probably important to note that the Department of Corrections makes up the bulk of the sheriff's office's budget. So it is it is the vast majority of the budget.
I'm concerned that your timing argument, not this particular part you've been talking about, but another feature of it, a large feature of it, really contorts our case law in a direction it's not going. You have the favorable decision, the favorable recommendation
Correct.
by the administrative law judge. And then you have the firing of the commanders a couple of months later. Now, of course, there's an intervening budget cut crisis, but you've just told us, well, the union activity was years before that, and the favorable decision was months before that. But we don't say that the mere passage of time conclusively bars an inference of retaliation. The timing picture here does not bar an inference of retaliation. We've said there's no bright line rule about how close the events have to be. So I'm concerned about that.
Well, that's correct, Judge, and I think an excellent case to look to understand why that is that Baines versus Walgreens case, which has a nice sort of description of a period of 6 years. It's several years, certainly, between the protected activity and then the later adverse action. But what that case had, and what the other cases have, where there is an extended passage of time, is they have glue that connects, they have connective tissue that connects those two events. Now, in the Baines case, it was the fact that the supervisor who was involved in the earlier protected conduct later intervened years later in a way that was extremely out of ordinary to say, do not hire that person.
Well, let me ask you about some connective tissue. There was a superintendent who was fired who testified at the Illinois Labor Relations Board hearing.
That's
in
correct.
addition to all the commanders who were obviously had their petition before the board.
Correct.
And who were fired. Was any other sheriff's office employee a witness at the Labor Relations Board hearing?
Yes, there were other witnesses. I do not recall the names of them, but I certainly know, I believe there was an attorney from the legal department who testified. So there were at least one other witness.
Were there any other superintendents who testified?
I don't believe so.
So the only superintendent who did testify was fired in the budget cuts.
That is correct. However, he was a witness for the sheriff. And it's worth noting that the sheriff ultimately did prevail in this matter before the ILRB in February 2018.
And that was later, though.
Yeah,
correct.
we're
It was
looking at
after.
the moment in time of fall 2017,
Yes.
November 2017
Yes.
to be exact.
Yeah. It is true that that individual was let go in the layoffs, along with, and I should be clear, it was not just the commanders who were let go. There were dozens of other employees. These cuts touched virtually every aspect of the sheriff's office, from IT to administration to other departments, the police department, court services. And numerous other positions were let go. Nurses were let go. Investigators were let go. Police were let go. Caseworkers, electronic monitoring, numerous other positions were let go from other divisions. But again, the important thing here was, oh, sorry.
Well, you know, it's still a very nagging thing that by letting all of the commanders go, the sheriff got rid of a very troublesome, adverse NLRB trial level decision that jeopardized his continued control over these commanders.
I guess I just don't see it in that, from that perspective, certainly, in the sense that, first of all, they were not troublesome in any sense, other than, yes, they did try to form a union, and the sheriff's office has a practice of when management tries to unionize, they oppose that. The sheriff's office is not against unionization. Almost 90%, I believe, of the sheriff's office is unionized.
But apparently the sheriff considered these people management.
Correct, yes, and so did the Illinois Labor Relations Board when it decided in February 2018 that they could not form a union. The other point I wanted to make...
Would a jury find it hard to believe an attorney's suggestion that they weren't considered troublesome when the commanders are able to put forward these kind of negative comments that some of the folks were making at the sheriff's department about the commanders and about their union activity?
I believe there's two comments that are several years old, Your Honor, and...
Did they take place during the union effort?
Did they take
They
place?
took place during the union effort, didn't
They did, which began in 2013, and the layoffs were in 2017.
So they were relevant to the union effort.
Certainly relevant, Your Honor. However, it's also worth noting, and I do not think a jury could possibly conclude that, for example, Ms. Jones-Tapia's comments regarding unionization or regarding union, which was an offhand comment that, regarding some AFSCME members coming to a meeting. It wasn't about unionization generally or trying to form a union or anything like that. But more importantly, as Your Honor started our discussion today with, Ms. Jones-Tapia tried to save the commanders. She put forward suggestions. She said, I think there's another way we can do it, and unfortunately it didn't work out. The sheriff's office put forward numerous other proposals to avoid layoffs completely throughout the summer of 2017 to make budget cuts that the county rejected. At any point during that process, if the sheriff's office had really wanted to retaliate against the commanders, they could have simply put them forward and eliminated them early on. They could have put them on the chopping block, and they never did that. It wasn't until 2 days after Chairman Daley wrote to the sheriff's office and said, you have to cut $62.5 million, and I need your proposal in 7 days. It was 2 days later that the issue of eliminating the commander position was first raised by Ms. Helen Burke and sent it to Matt Burke and said, what are the financial aspects of this and what are the operational aspects of this? And when those operational and fiscal aspects were considered, it revealed that they saved money. They saved millions of dollars by eliminating the commander position. And Chief Curry, who was the chief operating officer of the sheriff's office, the person who you want making these kinds of decisions, said, operationally, I can live without this level of supervision, which the Cook County Board had just said, why do you have so many supervisors here? And I can divide up their responsibilities among lieutenants and superintendents, and we can move on, and we can survive. So, Your Honors, I believe that no reasonable jury could find that plaintiffs would be able to meet their burden, that their layoffs were caused by their union activities, or that the sheriff's explanation that they selected them because it was operationally feasible, because they required budget cuts, was a lie. Counsel has conceded as much. The budget cuts were not a lie. They were a necessity. And it was a rapid, short period of time in which they needed to find people to put forward to the county. And finally, I'd also add that the individual defendants are entitled to qualified immunity for exercising their discretion regarding these budget cuts. And for these reasons, and as set forth in our briefs, Your Honors, we ask that you affirm the district court's judgments, and unless you have any further questions, I'll yield the remainder of my time. Thank you.
Thank you, Mr. Leinenweber.
Thank you.
Anything further, Mr. Castor?
Actually, Your Honors, I have nothing to add to my original argument in my brief. Unless there's additional questions, I would yield my time.
Thank you, counsel. The case is taken under advisement. Our next case for argument this morning is United States against Carlberg. Mr. Warson.
Good morning, Your Honors. Matt Warson for the appellant Scott Carlberg. We're asking that this court order that the district court grant the motion for judgment of acquittal, reverse the district court's denial of that motion. Our reasons are this. My client, Scott Carlberg, worked as an engineer on a railroad and was severely injured, exposed to electrocution. As a result of that injury, my client was deemed entitled to occupational disability benefits. He is entitled to these benefits so long as he cannot return to his former position as an engineer of locomotives. He was severely injured, both physically and mentally, and the injury also resulted in a settlement of a claim against his former employer, which netted Mr. Carlberg $450,000. Mr. Carlberg used this cash to purchase a tanning salon in Menominee, Wisconsin, rural Wisconsin, where he lived. And since purchasing the salon in 2015, ran it at a loss or as a break-even proposition. That is, not only spent his money through the settlement, but also incurred debts to his stepfather, incurred credit card debt, and so on and so forth, trying to run this business. And so it's our position in this court that the conviction should not stand, because if there was fraud committed here, it's immaterial. The government cannot show, as it must under the wire fraud statute, that the public fisc has been harmed and the fraud actually constitutes property fraud against the United States. And that's our position, Your Honors. I'm happy to answer any questions that the court would have.
I see none.
I do have one question. I noticed in the restitution. The restitution begins, it appears, about a month and a half before this entity, this tanning salon, was purchased. Is there an error in the computation of the restitution?
It's our position on appeal. Your Honor, I think there is an error, but it relates, in our view, to the fact that Mr. Carlberg is entitled to occupational disability.
I understand.
Okay.
I read your brief. Now, this would be a far more technical and not as advantageous savings to your clients, but it would be somewhat of a savings. It just seemed to me the restitution began to run a little early.
Okay, and is Your Honor referencing the gap between, I believe it's March 2015 and the actual closing in May?
I think that's basically the problem, as I recall, yeah.
Okay. Well, I think there was that inaccuracy in the record, and it's continued to be relied on by the government in this court, and that is that part of the fraud related to Mr. Carlberg having purchased the tanning salon in March, when in fact the transaction didn't close until about 2 months later in May. If I could conclude my remarks with just a vivid fact, which we argue supports entering a judgment of acquittal, and it's this: the government acknowledges this, that Mr. Carlberg was in fact living at the tanning salon. So my client was homeless, living hand to mouth, and it's not, there is no materiality. The government cannot and did not show that he defrauded the government out of money that he was not entitled to.
Let me ask you this based on the answer you gave Judge Ripple. Twice you've emphasized to us that he was entitled to the occupational disability check he was receiving. Is Mr. Carlberg disputing that the regulations have that check coming in, you're entitled to those up to certain earning thresholds? So you can still work if you're getting occupational disability, but up to a certain earning threshold, at that point, the government is interested in whether they might reduce your check. Does he dispute that?
I think there is a bit of a dispute there, Your Honor. It's our position that, and I believe the government, and we cite it, we rely on this quite heavily. It's in the district court docket entry 177-1, and this is the government's own evidence submitted during sentencing that acknowledges that Mr. Carlberg is entitled to occupational disability so long as he cannot return to his job as an engineer of a locomotive. Mm-hmm. And so purchasing this tanning salon doesn't negate that. Now, in connection with occupational disability, we acknowledge that there is this reporting requirement.
Yes.
But I don't think it applies as strictly to negate his entitlement to occupational disability, but rather
it's just a whole separate crime, right? Because the certification says, if I'm receiving a disability annuity and I fail to report work and earnings promptly, I am committing a crime punishable by federal law that may result in criminal prosecution and or penalty deductions in my annuity payments. So what's Mr. Carlberg's position on that certification?
Well, a couple things. He called the helpline constantly. Mm-hmm. We put that in our brief. Mm-hmm. And so we would rely on that he did have the intent to do his best to report. Mm-hmm. And so, but the second point would be that let's assume that he did not report properly and he had an intent to defraud the government. Our ultimate point is that my client is living in poverty in rural Wisconsin. He cannot materially defraud the government. There's no property fraud. He is entitled to this money, these disability payments, because he's never going to meet that threshold. And so I think whereas the government, and I'm sure I'll be corrected if I'm getting this wrong, but I think the government's argument is he performed substantial gainful activity. Irregardless of him bringing in money or not, he could work 22 hours a day at an unprofitable business, and that still constitutes substantial gainful activity if you don't report it to the government. Our position is that that is not so for two reasons. At trial, the government didn't proceed on that basis. They tried to present the tanning salon as a profitable business. But the second point is that, in fact, if my client's going to be convicted of a crime and serve a term in prison, there should be proof that, in fact, this was a material crime committed and the government has been deprived of property, and we just don't see that here.
Okay, well, I'm satisfied. You're into your rebuttal time, so I'm done asking you questions.
Thank you.
Mr. Fox.
Good morning. May it please the court, counsel. Charles Fox on behalf of the United States. So turning to Judge Ripple's question from a moment ago regarding the calculation of the restitution award, it's correct that the restitution award is based on disability payments that were made beginning in April of 2015, which is before when the transaction to purchase the salon closed. But as is discussed in that document that counsel was just referencing a moment ago, that's at R177-1, the RRB concluded that Mr. Carlberg was engaged in significant work activity beginning in March of 2015, meaning that he would have been disqualified from receiving the disability benefits payments beginning at least in April 2015 had they had accurate information. And therefore that supports the inclusion of those months before the actual purchase of the tanning salon within the restitution award. Turning more generally, the court should affirm the district court's ruling in full in this case. There was sufficient evidence to support the district court's denial of the defendant's motion for acquittal. The government's at trial established that the defendant made many misrepresentations regarding his work activity to the Railroad Retirement Board. And it also established that those were the sorts of misrepresentations that could affect the Railroad Retirement Board assessment of whether an individual remained entitled to receive disability benefits. Indeed, there was specific testimony from Clifton Rucker at trial that the Retirement Board would need accurate information about whether a person owned a business, how many hours he was working at a business, how many employees he had, et cetera, in order to make an accurate assessment as to whether an individual remained entitled to benefits and the level of those benefits. And those are the exact categories of information that the defendant repeatedly misrepresented to the Retirement Board and concealed by declining to respond to his annual reminders that he was obligated to provide such information. Now, the defendant's position, as was just elaborated, is something that he had to actually earn some income threshold and that he couldn't do that because he was living in poverty and living in the tanning salon. And there are multiple factual and legal issues with that position. The primary issue is that legally he didn't have to earn any threshold in order to be disqualified from receiving retirement benefits. He could be disqualified based solely on his work activity alone. And there was plenty of evidence put into the record at trial that the defendant was engaging in substantial work activity during this period. Additionally, to the extent it's relevant to the court, the defendant was only living in the tanning salon for a brief period of time. He wasn't living there out of poverty. He was going through divorce proceedings with his wife and apparently temporarily relocated there. But there's no suggestion that the defendant was somehow destitute during this period. And indeed, there was testimony that he was using significant funds from the tanning salon to pay off his personal credit card bills.
Now, of course, he says that, he's paying his credit cards from the tanning salon money to repay himself for the loan that he made for the purchase of the property. So what's your response there?
Well, I think the evidence shows that the funds were flowing to his personal credit card bills, and I don't believe there's sufficient evidence regarding whether he's paying off a loan that he gave himself to pay the purchase price of the salon. But in any event, it just doesn't matter, because what's relevant here is whether the defendant was engaging in actual work activity that would disqualify him from receiving benefits. That's really the basis that the court should be focused on, is the defendant's work activity rather than whether he was repaying himself for some sort of loan. It seems based on the defendant's reply brief that he is sort of conceding now that the types of benefits he's receiving are property under the wire fraud statute, but in any event, there shouldn't be any dispute that the almost $280,000 in benefits that the defendant received, as well as the sort of fringe benefits from the disability freeze, including tax advantages and Medicare coverage, constitute property within the meaning of the wire fraud statute. And the district court's calculation of the restitution award was also adequately supported by sufficient evidence in this case. The district court received both the document I was just talking about at R177-1 from the RRB, and also received extensive testimony at a sentencing hearing regarding the method that the RRB would have used to assess whether the defendant was entitled to continue to receive disability benefits had it been receiving accurate information, and the defendant does not raise any legitimate objection to either the methods of the retirement board making that calculation or the district court's reliance on it. If there are no further questions, I'm happy to yield the rest of my time.
Thank you, Mr. Fox. Anything further, Mr. Morrison?
Just one brief point. I'd like to address the restitution. Counsel just stated that appellant has no objection to this evidence that was put in at sentencing to support the restitution. We strenuously object. That testimony created a hypothetical world where Mr. Carlberg would be earning a salary of $60,000 in the largest metropolitan area. I think it's about 35 or 40 miles away, Eau Claire, Wisconsin. Of course, this is no comparison to what we have here. We have a business owner with a tanning salon in Menominee, Wisconsin, struggling to get by, actually paying other people to work for him at his salon. And so the district court relied on this world where Mr. Carlberg is earning $60,000 a year in Eau Claire, which just bears no resemblance to what actually happened in this case. I see I'm out of time. Thank you.
Thank you, counsel. And Mr. Morrison, the court appreciates your willingness to accept the appointment in this case. The case is taken under advisement. Our final case of the day is United States against Elliott. Ms. Christensen.
Good morning, Your Honors. May it please the court. My name is Joanna Christensen, and I represent Mr. Elliott in this matter. Mr. Elliott's Sixth Amendment right to conflict-free counsel was violated when the district court failed to obtain a valid waiver of the conflict of interest his attorney suffered under.
What is the conflict of interest you pursue?
The conflict of interest stems from the allegations Sample made against Mr. Elliott regarding smuggling drugs into the jail.
Mr. Sample was worried that Elliott had wanted him to commit a crime, but what is the conflict of interest? You seem to think that conflict of interest is anything that might go wrong in an attorney-client relationship. And obviously that's not true.
No.
It's not as if Sample had loyalties to some third party or a reason to pull his punches in the defense.
Yes, I believe it's a combination because he did have loyalties to the people who were paying his bills on behalf of Mr. Elliott. And there's a combination there because it's all interrelated, is that all of this becomes a division of loyalty for Sample. And his inability to perform as Mr. Elliott's lawyer and only Mr. Elliott's lawyer is compounded by the fact that he was worried about his safety, he was worried about his ethical responsibilities, his exposure to misconduct himself, and of course paying his legal fees.
I just don't get it. There may or may not be problems. We don't have to call them all by the name conflict. If a lawyer thinks his client has asked him to suborn perjury by presenting perjured testimony, for example, that's an ethical problem, but we don't call it a conflict of interest. We talk about the problem for what it is. I just wonder why you're trying to shoehorn this problem into the phrase conflict of interest.
Because it isn't a conflict. A combination of it is a conflict. And not all problems are conflicts. I'm willing to concede that. But in this case, there was a conflict here, and the district court failed to address it with Mr. Elliott. So Mr. Elliott did say, hey, I want Sample to stay on. He's a great lawyer. He's done this for me. All of that was said within this world where Mr. Elliott did not know that the conflict existed and the things that Sample was alleging Mr. Elliott had done. Now, I'll just address the appeal waiver briefly. Is that this issue can't survive the appeal waiver because it goes to the heart of the voluntariness of the plea. And we're arguing first and foremost it should be an automatic reversal because there was a conflict under Holloway that the district court did not address and force Sample to continue representing Mr. Elliott. I recognize that Mickens, the Supreme Court in Mickens, called Holloway a very narrow decision. However, Mickens noted that Holloway has a place where the Strickland analysis is not enough to prevent the denial of the Sixth Amendment right. So automatic reversal also would be appropriate under chronic, under the third type of chronic issue, which would prevent any lawyer from rendering effective assistance. And in this case, as I've already discussed, those factors would be very difficult for Sample, and in fact, were very difficult for Sample to continue representing Mr. Elliott.
Let me ask you about that. The government paints chronic as about denial of counsel altogether. You highlight chronic's language about, do we have a situation that would prevent a lawyer from providing competent representation?
Right.
So there's a mismatch with how you all paint chronic and its application to the case. Can you address that and why your view is the right view?
Sure. Chronic discusses the circumstances where prejudice that amounts to a complete denial of counsel. That's the basic holding of chronic, but it gives circumstances, right? And one of those would be, of course, where there's no attorney whatsoever. And that's obviously not the case here. And then there are two other examples that the court gives. One is that the attorney didn't subject the case to any adversarial testing. And then the third is that circumstances that are likely to prevent any lawyer from rendering effective assistance. And that is the third situation that we're going on under. Obviously, he had his attorney, and to the extent that it is done in plea proceedings, he negotiated with the government, which is really the best can be done. But any lawyer in this circumstance would have a difficult time continuing to represent a defendant.
Let me ask you another question about the appeal waiver. You say that the conflict here goes to the voluntariness of the plea. Is it fair to say that the presence of a conflict here goes to ineffective assistance of counsel, which is carved out of the appeal waiver? Is that a fair way to look at it? Because if you've got a lawyer laboring under a conflict, you cannot then have effective assistance of counsel. And so it doesn't become an IAC claim that we're then, saying should be dealt with on collateral review. It is, as both of you seem to agree, an issue about a district court's error. But it's an error rooted in effective assistance of counsel. Give me your thoughts on that.
I think, and this may be, splitting hairs as to the wording that we're using. I'm not making an ineffective assistance of counsel argument. Right. And the reason for that is that even though the appeal waiver allows for it, the Strickland type of analysis is better done on 2255. The questions asked are different. But the Mickens case allows for this remedy that addresses cases that are outside of Strickland, that don't apply to the Strickland analysis. And even if you get beyond automatic reversal to Kyler versus Sullivan, that doesn't ask about prejudice to the defendant. That asks about potential adverse effects. So the language is very different in the way that we talk about it. It may come down to the same concept of ineffective assistance. It comes from a different direction.
But I guess I'm not saying that you're making, because it's clear to me that you are not making an ineffective assistance of counsel claim. But the question is merely about why this doesn't fall within the appeal waiver. If the appeal waiver says if it's got anything to do with ineffective counsel, you can appeal it. This has to do with ineffective counsel by my reading of your argument, because it's about counsel having a conflict. That doesn't mean your claim is ineffective assistance of counsel.
Mm-hmm. I see what you're asking, and that entirely could be the exception that's carved out. My understanding is that those appeal waivers that contain the exception for ineffective assistance of counsel really are addressing the Strickland ineffective.
And how do we know that here? Is it just this language that's in the plea that I'm looking at?
I think that's what we've got in this case about it. I mean, it certainly wasn't discussed
Right.
on the record. For me and my analysis, it's that is usually interpreted as a Strickland type of error prejudice analysis.
But is that just custom, your analysis custom, or is it based in some sort of case law that says when you see these black and white words in the plea agreement, it must only be talking about a pure Strickland claim?
I don't think I have a case that says that. I think it is based on practice and also my knowledge that didn't used to be an exception in appeal waivers, that you waived everything, including effective assistance or ineffective assistance of counsel. And the fact that it's now become essentially a Strickland analysis for 2255. Okay. I have in other cases made arguments about that section of the appeal waiver under Strickland, and it's said, no, you do this on 2255, or you should have. So unless the court has questions, I have just a minute left in my time, and I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, Ms. Christensen. Mr. Reitz.
May it please the court, Brian Reitz for the United States. We agree with the court that this was a problematic attorney-client relationship, but not a conflicted one. We think our brief is sufficient to show why there's no actual conflict and no adverse effect. With that, I want to jump right in. Judge Jackson Aquilumi, you asked two questions that I want to address. First, about chronic. We agree that chronic said there's a third factor, possibly, where no attorney could effectively represent the client. That this is not that case. In fact, Sample's representation of Mr. Elliott shows that any attorney, and in fact the attorney that has the purported conflict here, could effectively represent Mr. Elliott. Mr. Sample's representation after this purported conflict was effective.
Well, that's kind of weird, because that is looking at what happened later to then go back in time at the time that Sample initially raises the conflict and say, see, there was no problem. You couldn't possibly have been as hot and bothered as you were the day you told the court you needed to withdraw.
Oh, I agree that Mr. Sample was hot and bothered the day he wanted to draw. Nothing of our argument is about that. However,
well, you just argue that because we later see that he got through to sentencing, everything was fine.
yeah, I think it proves that it was. In addition to the fact that there was no actual conflict. Nothing he said that day indicated that there was an actual conflict. I mean, certainly he said there was an irreconcilable conflict, but he didn't identify any fact that would place him in a position where he had incompatible interests.
I am a little concerned about that too, because what we have is Mr. Sample saying, not just that Mr. Elliott tried to use me to commit a crime. There's already a crime there. As you know, attempt crimes are crimes.
Correct.
The crime was completed, attempted possession with the intent to distribute.
Yes.
Then we also have Sample saying, I actually had in my hands the legal pad with the 21 strips of drugs on it. And I took it, I locked it up. So now we have Sample explaining to the judge that he's in possession of drugs, or at least he was on that day. We don't know where the drugs are now. Sample hasn't said. He's been careful not to say. He's trying to obviously protect his exposure. So we have Sample now in possession of drugs, either still to this day at the moment he's talking to the judge, but at least the day he visited the jail. You know, we also have the fact that we don't know. Somebody sent those drugs. So we don't know if the person who sent the drugs is now looking for the drugs because the drugs never made it to Elliott. Sample doesn't know that either. Who's looking for him? Now that the drugs are missing, and we know that drug suppliers like to know where their product is. Okay, so now the product is poof, it's disappeared. Sample doesn't know who's looking for him. And his client is a bit unhinged because he's not just a random client sitting in jail. He's one sitting in jail for murder for hire, okay, who is also incidentally asked Sample's firm about smuggling drugs into prison. So this constellation of facts is certainly disturbing and certainly takes, I think, Sample's request to the court out of a theoretical, I'm concerned there, I worry there's a problem. It elevates that beyond, I see several concrete problems, not a worry that there's a hypothetical problem. Are you saying that we should ignore those facts?
I think under this court's precedence, the only thing that makes this an actual conflict is if Sample was involved or the authorities thought that he was involved in the actual crime. And nobody thinks that here. He said that he was not, so courts presume that attorneys speak truthfully to them. Nothing indicates that he was. He hasn't been charged. I can say that we don't know where the drugs are because we weren't investigating him. The only thing that makes this an actual conflict under this court's precedent is if Sample himself was involved in the crime.
But Sample doesn't know that the day he's moved to withdraw. He's moved to withdraw shortly after this happens. And
Sample does know that he's not. No, I disagree with that. Sample
Okay.
said, I stopped this attempt. I'm not involved in this crime. So I respectfully disagree. He knew that he was not involved in the crime. And the court was allowed to rely on that assertion.
But he also knows that he was or is still in possession of drugs.
Yes. I mean,
Okay. Now,
yes.
and the language you're referring to, are you referring to our standard set forth in Montana?
Montana, and there's a number of cases.
Okay, so
Yeah.
it talks about an attorney being implicated in the crime. But have we defined what that means and who gets to judge? What is implicated and who's judging what's implicated?
I suppose it's an objective general standard, and implicated means he did some act that is a crime or he is under investigation. All these cases when someone is under investigation, there is facts in the record that the attorney was under investigation, or it maybe was so obvious that he would be under investigation.
So the day he moves to withdraw, he hasn't heard from anybody that he's under investigation. But later, if he hears a week later he's under investigation, he gets to come back.
Yes.
And then he's implicated, and then there's an actual conflict.
Then it's different if there's a fear of retaliation. Yes, absolutely. And we leave that to attorneys because attorneys are best positioned to know if they have an actual conflict. So yes, the situation could have changed.
Now, why isn't Sample telling the court, I'm concerned about my safety, the safety of my firm, and you ought to secure the courtroom and make sure all security measures are in place? Why is that not Sample reflecting a fear of retaliation?
Fear of retaliation is specific to the government prosecuting him, and so because that places him in a choice where maybe he pulls his punches because he doesn't want to get prosecuted. Fear of retaliation from a client is not an actual conflict. I mean, it's one of the reasons of many, I suppose, that I wouldn't want to be a defense attorney, but defense attorneys are sometimes afraid of their clients. That is a problem. It's not a conflict. The safety aspect is not a conflict. I'm aware of no case, and certainly no case has been cited by Mr. Elliott, where a fear of a client is an actual conflict. That is part of the difficult job that I don't envy that defense attorneys often have to do.
Well, I'm a little bit concerned about his language, because it seems to me his language is not restricted to fear of Mr. Elliott, but now we know other people are involved. Who's supplying these drugs? Who is Elliott working with? And as I mentioned before, who may be looking for these drugs that have now gone missing?
Your Honor, I think that is a decent inquiry for a 2255 hearing. But this record right now, we don't have it, and Mr. Elliott has the avenue in a post-conviction motion to discover those things. Now, we don't think whatever that is rises to an actual conflict unless there is some evidence that Mr. Sample was involved, which there isn't, and he disclaimed involvement. But until we can show that, or he did something that he's actually afraid that he might get prosecuted for, we are outside of actual conflict under this court's precedents. And I mean, I cited my brief precedents from many circuits. With that, Your Honor also asked about what Mr. Elliott's claim is. So, yes, he can raise a guilty plea, involuntariness claim. Yes, he can raise an ineffective assistance to counsel claim. His conflict claim is an ineffective assistance to counsel claim, so it is thereby not waived. We agree with that. However, everything is subsidiary to that. His complaints about the court, any issue he has with the court, all depends on whether there was an actual conflict, and that is an ineffective assistance of counsel analysis. So the court here to find that the district court below erred or that Mr. Elliott's guilty plea was involuntary or unknowing would have to engage in the conflict analysis, which is an ineffective assistance of counsel analysis. The court has said in Stoya and Kosha that Strickland and Culler versus Sullivan are two ways to show a deprivation of the Sixth Amendment right. So Mr. Elliott cannot win his case here without proving a form of ineffective assistance to counsel, which he might do on 2255, but he has not here because he has not shown an actual conflict. We talk a lot about actual conflict. Even if Your Honor is worried that this was a conflict, there has been no showing that there was an adverse effect on Mr. Sample's representation. And with that, I actually do want to clarify one point in the reply brief. Mr. Elliott says that the two guilty pleas were exact, I think is the quote from the brief. That is incorrect. So the plea offer that Mr. Elliott declined first.
Actually, instead of addressing that, because that much is clear, can you go back to adverse effect and your theory on why there is no adverse effect, simply because he pled and the government saying pleading was the right thing to do here and the best thing to do here? Does the analysis end right there, I'm asking? We certainly have case law that suggests that could be the analysis.
I think in this case, yes. I don't want to disclaim the ability on 2255 of Mr. Elliott to show some more specific action that Mr. Sample could have taken but didn't because of the purported actual conflict. But here on appeal, Mr. Elliott's only argument seems to be that Mr. Sample wanted to rush a guilty plea, and the record does not support that, and the guilty plea was objectively a reasonable thing to agree to, and it was beneficial to Mr. Elliott. He, in fact, went so far as to thank the prosecutor at the sentencing hearing for withdrawing the sex crime so he didn't have to register as a sex offender. So I think on the argument raised here, it is sufficient, but this can be developed in a 2255 hearing. If there are no further questions.
Thank you, counsel.
Thank you.
Anything further, Ms. Christensen?
Yes, Your Honor. I think first and foremost, it's a little hard to know exactly where to start, but first and foremost, Sample was involved. He walked those strips in a legal pad into the jail. Now, he claims he didn't know they were in there. He had a suspicion, and then later went back to his car and apparently found out. But blind mule cases are still felons. And if any defendant gave us that story, oh, well, I didn't know it was in there, and then I thought about it, and still be guilty of attempt. So we are not arguing that Sample wanted to rush the guilty plea. We're arguing that Sample wanted a guilty plea because of this exact situation, that it would insulate him from the conflict issue being considered on direct appeal, where it has a far greater chance than the less than 1% chance that he would have on a 2255 raising ineffective assistance of counsel. So
I need you to address adverse effect.
Yes. So the adverse effect is that advising to plead guilty and how that happened, because nothing was done aside from a competency exam, which was the second. I think we all agreed that Mr. Elliott was mentally ill. And it was still almost a year between the conflict hearing and the guilty plea hearing. The fact that Sample's telling the court that Mr. Elliott is continuing to commit crimes, trying to use him to commit crimes, is an adverse effect that would have happened, certainly to the court's evaluation of this case. And then we cannot ignore the cross-examination issue with the mother and grandfather in this case. That was a significant adverse effect that Sample would have wanted to avoid. So I see that I'm out of time. I would ask this court to reverse and remand. Thank you.
Thank you, Ms. Christensen. The case is taken under advisement, and the court will be in recess.